So my case that I'm going to cover is called Free Speech Coalition versus Paxton out of the Fifth Circuit. And this involved a Texas statute that is the type of statute that has been enacted by many other states as well. The statute requires the operator of an adult website, if 30% of the material on the website is, quote, obscene as to minors, unquote, then that adult website has to ensure that the age of any person who accesses the website is verified to ensure that the person is over age 18. So the court upholds the law in a 6-3 vote, and 6 conservative justices in the majority and the 3 liberal justices in dissent. The concept of speech obscene as to minors has been around for a while. We all know obscenity is somewhat of a difficult to define term. When we talk about obscenity and we cite the famous Potter Stewart line, "I know it when I see it," that's referring to obscenity as to adults. And that has been interpreted to be a very narrow category of speech. I mean, just almost unbelievably vile, violent and sexually explicit depictions. Whereas speech obscene as to minors would be a broader category that includes things like what we would probably describe as softcore pornography, Playboy, that sort of thing. And it comes from a case called Ginsburg versus New York, in which the court upheld a law that prohibited the sale of, they were called girly magazines in the statute, but it meant things like Playboy, Penthouse, to individuals who were under 18 years of age. So this naturally, back in the 60s, is happening in convenience stores and that sort of thing. It's not happening online. And the practical reality was if an individual walked into the store and looked like he might be below 25, just like it is with buying cigarettes or alcohol now, the store owner would have to card the person and say, "Please show me your ID. I need to know that you're over 18 before you purchase this magazine." And the Supreme Court upheld that law. And it upheld it under rational basis review, right? The most lenient standard of review. And the court says the state has an interest in protecting minors. Minors do not have a First Amendment right to access this material, full stop. Fast forward a few decades, 2003, 2004, we're now in the early internet age, and we have a case called Ashcroft versus ACLU. And this involves a federal statute that says before an internet provider posts or distributes any material that's obscene as to minors, the internet provider must verify the age of the person who's accessing the material, or else the internet provider has committed a crime. The Supreme Court strikes down that law. And it essentially says, it's a cryptic opinion, it's on a preliminary injunction. There's a lot of language about we don't really know the full record yet and technology is developing rapidly. But the court essentially says, this is too burdensome on adults. We agree that children don't have any right to access this material under Ginsburg, but because this places a heavy burden on adults' ability to access it, we're going to use strict scrutiny. It's a content-based regulation of speech. It looks at the content of the material to see if it's obscene as to minors. And as a practical matter back then, the court says an adult's going to have to hand over his credit card or is going to have to upload a driver's license, and those things can be very risky during that age of less data protection than we arguably have now. So now fast forward another 20 years and we're up to Free Speech Coalition versus Paxton, and we have a couple things that have happened, right? Number one, terrible things have proliferated on the internet when it comes to pornography. Your average 12-year-old has access to the worst sorts of pornography an adult could have looked at decades before. And technology has gotten a lot better when it comes to age verification. There are third-party providers that verify age without ever looking at a driver's license, without ever looking at a credit card, and without the adult website even knowing who the person is. All that third-party verifier does is tell the adult website this person is over 18. So with those developments, the court has a case from this circuit that says what level of scrutiny applies to this Texas law. The Fifth Circuit says this is like Ginsburg, but just for the modern age, and applies rational basis and easily upholds the law. But over a strong dissent from Judge Higginbotham, who says Ashcroft versus ACLU controls. The Supreme Court says not rational basis, not strict scrutiny, but intermediate scrutiny. And the opinion by Justice Thomas essentially says that we take it as a given, minors have no right to access this, but we also don't see a burden on adult speech that's significant. Any burdens are incidental to policing the line between adults and minors, and therefore it's not actually a content-based restriction, it's an intermediate scrutiny restriction. Essentially, I kind of analogize it to a time, place, and manner restriction. Adults can look at this, children can't look at it. There has to be some way to determine the difference. So long as that way doesn't violate intermediate scrutiny, then we're going to uphold the law. I think one interesting doctrinal development in this opinion, which applies intermediate scrutiny and then upholds the law on the merits, is that Justice Thomas, as you might expect, looks quite a bit at the history and the tradition of how states have regulated pornographic speech or speech obscene as to minors. And Justice Thomas says, look, there's not a single state in the country that lets a 17-year-old walk into an adult movie theater or walk into a strip club. They all will card you. So given that that's been our history and tradition for decades, if not centuries, how could we possibly be applying strict scrutiny to this when it becomes part of the online world? Okay, Ashcroft versus ACLU is out there, but that was the early days of the internet, and that was very burdensome on adult speech. Now we've had technological developments, and we can distinguish that case. So we've seen a lot of history and tradition coming into our constitutional jurisprudence. We think of it mostly in terms of substantive due process, like cases like Dobbs, Second Amendment, cases like Bruin. Now it's starting slowly but surely to come into the First Amendment, which the First Amendment had traditionally been pretty much whatever the Warren Court said, and the decades after the Warren Court, it was a very judge-made doctrine. And now the Supreme Court is starting to look behind that a little bit and take a look at the history and tradition of what type of speech was protected and what type was not protected in informing the traditional judgment of how scrutiny applies to those laws. So bottom line, Fifth Circuit affirmed here 6-3. The next stage of these cases, there's always the next stage, is now going to be whether you can require age verification for social media and parental consent for social media. Many states have passed such laws, and they are now percolating through the court system. Whether the Supreme Court will treat those as similar to being obscene as to minor speech, I have my doubts, but that's the next stage of the game on the First Amendment.
Aaron, can I ask a quick question about that? Does the Texas law protect adults' identities at all?
Yes, the Texas law requires that the adults' identities cannot be retained by the third-party age verifier. It has to be a secure method.
Okay. I was just wondering about how incidental the burden was.
Right, and that was a lot of the dispute in the case. And of course, it's only on a preliminary injunction, so I suppose if it went back and the trial court made detailed findings that there was an actual heavy burden on adult speech, maybe we would see a different outcome, but that's not what the court saw at this stage.